Hi, I'm attorney Gregory Dell, joined by attorney Stephen Jessup, and today we're going to talk about the number 2 most common reason for a disability denial, which involves a change of definition and also the vocational review that's associated with that. And Stephen, it's always a crapshoot when people call us and say they've been denied, because there's probably our top 10 reasons for why people get denied, but more often than not, it has to do with this change of definition. And in this video, I want to discuss some tips about ways that people can deal with this denial, talk about some of our experiences from scenarios that we've seen with these denials so that we can hopefully offer some assistance and help to people that find themselves in this exact situation. So when someone initially calls you and says they have a change of definition, what does that usually mean within the majority of the disability policies that you see?
Well, that just basically is going to mean the change in definition of disability, meaning going from the inability to do your own occupation to this idea of the inability to do any occupation that's based on your training, education, and experience. And in some situations, the policies will explicitly say a certain percentage of income would have to pay a certain amount of your pre-disability earnings. But this general idea of going from you can no longer do your own job to no longer being able to do any job.
And a lot of people who are watching this video have probably been on claim for approximately 12 to 18 months, and they've received some kind of letter that we're doing a reevaluation of your claim for a change of definition. Why are they getting that notification, and what is likely going on behind the scenes with the disability company to evaluate their claim?
Yeah, and Greg, I've been personally seeing an uptick in calls from people who've received these letters. Generally 6 months prior to this change in definition, the insurance company is going to do their review. So when you get that letter, know that they may be putting you under surveillance, contacting your doctors, maybe arranging for independent medical evaluations. They'll be certainly reviewing like your social media accounts and online presence to see if there's any information that they can garner that shows ability for work or functionality. They may have you meet with one of their people. So when you get that letter, know that they are actively looking to see if there's a basis to deny your claim.
And when people have this change in definition, I want to talk about some things that they can do on their own to anticipate this so that they can put themselves in the best position to be prepared for the change. So what do you usually recommend to your clients when they do receive this letter?
Contact your treating physicians. I think that's first and foremost probably the big thing. Your doctors who have written you out of work or filling out your forms to see if the insurance company's reached out to them. If you haven't been to the doctor, you may want to get updated to the doctor at that point as well, just so you're starting to build additional medical evidence. Because at the end of the day, some of the most important stuff that they are going to look at is what is in your medical records.
And in terms of besides doing a medical review, what other types of things is the disability insurance company going to do a change of definition evaluation?
Internally speaking, outside the medical review, after the medical review is done, they're going to do some type of vocational review, whether it's they call it an occupational analysis or an employability analysis report. What they are doing is taking the restrictions and limitations that your insurance company's doctors are placing upon you, like what you can, in a lot of situations, can physically do under this idea of the Department of Labor standards of sedentary, light, medium, heavy, very heavy work. And then what they do is they just take those simple restrictions and they try to find occupations that they think based on your training, education, experience that you can do. And then a lot of times my biggest gripe with these reports are they're not actually looking at what the actual material duties of these other occupations are. They're simply looking at the physical demand level. So if the doctor, for instance, for your insurance company thinks that you can do, sedentary work, well, they're really focusing on our jobs that realistically may transfer skills you may have skills for, but more importantly, they're just looking, hey, is it a sedentary job? If it is and it meets these other requirements, here's a job we think you can do. So those vocational reports, in my opinion, more than anything, beyond the medical reviews, can really be used negatively to deny a claim. And you and I have reviewed enough of them to know that quite often it's really, they're not done well. It's a lot of junk in there, and they're overly simplified and they're missing the bigger picture. I just recently looked at one where they identified jobs for a gentleman I represent who has probably the most unique skill set I've ever come across. And they said, well, there's these other jobs that exist in the national economy. So in the national economy, right? But not in his location. None of these jobs were found to be within 50 to 100 miles of where he lived available for him to get. But still, his insurance carrier, they didn't care about that. They're just like, well, we think you can work at this level. These jobs exist in the national economy, and that was that for them, and they upheld the denial of the appeal.
Stephen, a lot of the people who usually call and have this change of definition, they're under the impression that if they can flip burgers at McDonald's or something like that, that's going to be the definition of any occupation, and if the disability carrier finds a job like that for them, then they're automatically going to get denied. Is that the way it usually goes with the change of definition vocational review?
No. It is really predicated on this idea of what your training, education, and experience are. They're going to be similar type jobs. And some policies will have an income component. We'll say, this job would have to be able to pay you 60% of your index pre-disability earnings, which is generally more than what you're actually making in a disability benefit. And even those that don't say that, explicitly in the policy are still kind of taking a look at that range of monetary amount. So it's not going to say you can go back and do some type of menial job that pays you, minimum wage or something. It still has to be predicated upon your prior work experience and an earnings component, either, specifically as defined in the policy definition itself, or in a generality. You will see that they will do that. So people don't need to worry that they're going to go to those lengths to say, oh, we think you can work now, you're not going to get your benefit anymore.
And Stephen, should the person who has whatever their own occupation was, let's assume it was a sedentary classification. You were talking about those Department of Dictionary of Occupational Title, Department of Labor classifications of light duty, sedentary, medium, or heavy duty. And let's assume the claimant had a known occupation definition of disability, whatever it was, and they had a sedentary type occupation. Now the change of definition is coming up. Should that person be concerned? Because how much lower than a sedentary type classification occupation can you go? And does that person still need to have concern for the change of definition if they already had a sedentary type job before the change of definition?
Yeah, 100% they need to be worried, because we make arguments all the time. Well, if you determine he couldn't do his own sedentary job for the past, 24 months, why now all of a sudden can they magically do some other type of sedentary occupation? So there does need to be a lot of concern there, because the insurance company has no financial disincentive for denying you. At the end of the day, if they're wrong, all they owe you is the money they haven't paid you. So if they can find some type of road to deny you, they certainly will. And a lot of times it doesn't make logical sense. I speak to people all the time who contact us when they've been denied at this point, and they have questions. Well, how the hell could they do this? How could they come to this? That's a great question. We don't know, outside of the fact that logically it just makes no sense. It's really, in my opinion, a financial business move, because a certain percentage of people, as you know, just let it go. They don't bother going through the appeal process, or they just don't want to be bothered anymore. And if the insurance company is only facing having to pay you what they owe you, what's the financial disincentive for not denying your case? So you do have to be very careful when it comes to those things. You have to remain vigilant. Even in situations where sometimes we have clients who, especially if they were high wage earners, so they have a high disability benefit amount, and their definition of any occupation does have an income component, that it has to pay them 60% of pre-disability earnings or 80%. In some situations, it really almost turns it into a de facto own occupation policy when we do our analysis and evaluation, where the only job they could really do that meets certain requirements of the policy was the job that they were doing. I will still see denials in that case. You always have to be with the mindset, the insurance company is not making money off you if they're paying you. So they're always going to try to find a way to deny you. So you do have to stay on top of your medicals, the information that your doctor's relaying, all those types of things.
Now, Stephen, another common issue that we deal with all the time that I feel like is somewhat of a misleading trap. There's this requirement for all the people who have the group disability insurance policies that they have to apply for Social Security disability. Now, we're not Social Security disability lawyers, but we know a little bit about the standards and the thresholds of what's required to get approved for Social Security disability. And the definition appears to be somewhat similar at times to the any occupation definition of disability in a group disability insurance policy. So more often than not, because we know that only 15% of the initial Social Security disability claims are approved, therefore 85% are denied. So how often do you see the disability insurance carriers heavily lean on the fact that the claimant's been denied for Social Security disability, which is similar to an ENIAC definition of disability, and since they got denied for Social Security disability, the disability company basically says, well, you didn't get Social Security disability, so we don't think you're disabled. How do you deal with that?
Yeah, it's interesting because when they do use that against someone, it's very targeted, direct, and specific, in my opinion. A lot of times, for instance, we know age is a huge component of Social Security. So if you have a younger person on disability that's below the age of 55, and they're denied Social Security, a lot of times it's age related. So insurance companies are kind of sensitive to that. Where it really becomes problematic, though, and I've seen it in denial letters where they have received a copy of the denial letter with the judge's findings and opinions, and the vocational people and the Social Security Administration saying, we think you can do light duty work and you have this physical ability and that. If there's stuff that's specifically negative to you in a denial letter, your insurance company will 100% hone in on that and say, even the Social Security Administration finds this as well, so they'll rely on it there. So you almost have to be careful too about providing them with, detailed, if you get the full opinion on a denial, because they'll use it in that situation. More often than not, actually, I see it where they are trying to disavow themselves of the Social Security when they're denying you. They give you pay lip service to the fact you have Social Security, and in your denial letter, it's pretty much form language, cut and paste. We have information that wasn't available to the Social Security Administration, i.e. their medical reviews, if they did an IME, vocational reports, that stuff. And since we have that, that's why our opinion is different from the Social Security Administration, and we're denying your claim now. So I think a lot of people get lulled into a pseudo false sense of security that Social Security's approved them. Their disability insurance carriers should. The law is pretty clear that receipt of Social Security does not mean a private disability insurance carrier has to pay you. They just have to consider that as evidence of your disability as part of their review.
And then the last topic I want to talk about is the strategy, basically another strategy which we haven't touched on in terms of how to deal with this change of definition, which is to hire a vocational rehabilitation expert, number one, and number two, to possibly have a functional capacity exam conducted. And I know we've done extensive videos on both of those things, and I encourage people to look those up because they both have their nuances and how you go about a vocational consultant and what kind of information the vocational consultant should review, and whether or not the vocational consultant should do a labor market analysis, which gets involved with even if they come up with jobs, are the jobs even available within a reasonable range of where you live? Because if you live in Kentucky and they find you jobs in New York City, that's as good as a job not being available. They can't offer you that kind of thing. And then also, that we've recommended claimants do functional capacity evaluations to determine what their functional restrictions and limitations are going to be regardless of what the job is. And especially when you switch to an any occupation definition of disability, it's important to do this kind of quasi-objective type testing to see what you can do in an 8-hour day with reasonable continuity for 40 hours a week, because that becomes the threshold. So I encourage you to look at our videos that we've done about functional capacity. Look at about a vocational expert. Feel free to contact Stephen or myself to discuss your options if you're in this change of definition, if you've been denied. We always talk about the remedies and steps that you have to take, whether it's file an appeal, if you have a group policy, or file a lawsuit, obviously, if you don't have a group policy. The most important thing that we can offer you at this time is to contact us for a free initial consultation. We'll review your denial letter if you've been denied. We'll review your policy. We'll let you know what your options are right away. All of our clients are located all over the country, so we welcome the opportunity to speak with you. We also encourage you to spend a little bit of time on our website, search by your company, your medical condition, your occupation. You're going to find a lot of helpful information that's going to put you in the best position to keep your benefits going for as long as you want them, and possibly as well help you to get yourself back on claim by some of the tips and information that we're providing for you. So should you need us in the future, we look forward to the opportunity to speak with you.